where to and what's going to happen with contractual relationships between parties such as tenants and landlords. The relationship between tenants and landlords doesn't only extend to commercial tenants and landlords, but could also relate to residential property. And there's a lot of things are similar, but there's some differences. And hopefully we can touch on some of those. As Lisa said, if there's any questions, hopefully I'll address a lot of the issues in the next few minutes, and then we can handle questions afterwards, and I'll try my best to answer them. One thing for sure is that there's no black and white answer. It's not clear cut. Nothing is clear cut in this. And I think what's going to happen in the long run is that there's going to be some litigation, no doubt, and that will certainly set the tone for how these things are going to be handled going forward. The tenant-landlord relationship is not something that's just for today and just during the lockdown period. The relationship has to continue after the lockdown period. And my view is that the fallout from this virus and the epidemic is going to last for a very, very long time. And as a result, it's going to affect people financially, emotionally, and all the rest of it for a long, long time. And whether or not businesses are going to, and tenants are going to be able to recover to a point where business becomes normal is a huge question, and how long that's going to take to happen. But let's get into it, and let's talk about the relationship between landlords and tenants. And this talk is not specifically aimed at either one of them, but we're going to look at it from both their points of view, because they're both equally affected. And there's two parties in this relationship, like any relationship. The issue is that it's a relationship. And that's the underlying theme of what we're going to talk about. And the way to resolve it is going to be through some kind of a relationship mediation or agreement or something like that, that's going to allow both parties to have some sort of comfort on the way forward. Clearly, there's a contract in place when there's a lease. And a contract is a contract, and the courts will uphold contracts. There's no question about that. Both parties have obligations to perform. They have to do certain things. Just for some examples, a landlord has to make sure that the building or the premises is in good condition. He has to make sure that services are rendered. He has to make sure that the premises are available to the tenant for the purpose that he's letting the premises to the tenant. And from a tenant's point of view, he has to pay his rent. He has to look after the premises. You may have to, if it's a commercial lease in a big shopping center, you may have to comply with certain trading hours. There's all sorts of obligations for both parties. In a residential lease, similar principles apply. The landlord has to make sure that the building is properly maintained, appliances, if they're installed, are in working condition, plumbing is working. Tenants are obliged to pay their rent, they're obliged to look after the place, and when they move out, they're obliged to make sure that it's returned in a condition similar to that on the day when they took it over. So the terms of a lease are very important, and each lease might be slightly different, and therefore each case might be slightly different. So you may have a very specific relationship with your landlord or your tenant, and that relationship is governed by the terms and conditions that are contained in the lease agreement, and you're both bound by that. Now, I've spoken a bit about relationships, and really this comes down to an issue that's been spoken about quite a bit recently, and that is the principle of Ubuntu, where no matter what the dispute is or what the situation that we find ourselves in, the spirit of trying to work together to resolve the problem is going to be all important in this case. And in many cases, as with employment relationships, there's lots of employees losing jobs, there's all sorts of things happening. And it's up to all the parties to try and work together, to try and find a solution to the problems that they may have. And I can tell you that legal action is not the best route to go. Nobody wins with a legal fight. It's too expensive, it's unpleasant, very time consuming, may cause long delays, and all sorts of things happen. And at the end of the day, there's no winners. So the only way for these kind of issues to be resolved is through some kind of coming together and working together to overcome the problems that are existent for all the parties that are involved. Now, I mentioned a lease, and I'm going to try and share a page. I just want to see if I can do that. If we have a lease, and I said to you that there are terms and conditions, if one of the parties doesn't comply with the terms and conditions, it's what we call a breach of the lease. So there's a breach of one of the terms and conditions, which that party is obliged to perform, and then the other party can put them on notice to perform. To give you one or two examples, let's just assume that a tenant doesn't pay his rent. He would be in breach, because I would assume that there's a clause similar to something that says rent is payable on the 1st of the month in advance, and if you don't pay it and by the 7th of the month you still haven't paid, you're in breach as a tenant. And the landlord can then put you on notice to perform, and then the landlord would have certain remedies. Those remedies might be to terminate the lease, to lock up the premises, all sorts of things, depending on the terms and conditions contained in the lease. That's what a breach is. From a landlord's point of view, if the landlord, for example, didn't make the premises available to the tenant for whatever reason, he would be in breach. If the landlord's obliged to maintain certain services, let's say the main water supply into the premises, and something goes wrong with it, and the landlord doesn't fix it, as might be his obligation, then the tenant could put the landlord on notice to perform, and he would in turn have remedies. A lot of those remedies, unfortunately, end up in court cases and summonses and all those sort of things, which, as I've said, is not a very nice situation. It's not a pleasant thing to have to go through. So what is the situation with the current situation in South Africa, where we have this coronavirus pandemic and the government have created laws and they have imposed a lockdown? That lockdown is going to be partially lifted, but there's still a state of I'm not sure what they call it, a state of emergency or state of, we're going to be in a lockdown in principle for the next few weeks anyway. Does that then amount to a breach of contract? If the tenant, for example, cannot occupy or go to work, occupies premises, or if the landlord is unable to provide the premises. I don't believe that that amounts to a breach. I think that there's something else that is relevant here. Now, because a breach is a breach by one of the parties only. The key here is that in the current circumstances is unable to give occupation of the premises, and the tenant is unable to take occupation of the premises. Not because of any fault of theirs, but because of the situation with the law of the land, which has been imposed on everybody. Now, there's a concept called force majeure. Certain leases have clauses in them relating to force majeure, and if there is a clause in the lease relating to force majeure, then it's very important that the terms and conditions of that clause are looked at and applied in respect of the current situation. I mentioned in the beginning, we can't contract out of a contract, or we can't walk away from a contract. So if there is a force majeure clause, some leases have them, some leases don't, then the force majeure clause must be interpreted and applied to the particular circumstances. But what is force majeure? Force majeure is an oh, sorry, I want to just share my screen with you. 1 second. There you go. Force majeure could be defined, there's lots of definitions, as an unforeseen event or force or circumstance which is beyond the control of the parties to an agreement and which renders the contractual performance impossible. Let's just take each of those red bits and try and establish whether that actually applies to the current situation. Is this coronavirus pandemic and the lockdown and all the consequences arising from it unforeseen? I would think it is unforeseen. Nobody saw this coming. It's a force, it's a circumstance which is beyond the control of the parties. Could any one of us have controlled this? I don't think so. It's not in the control of the landlord. It's not in the control of the tenant. So neither party is at fault. Remember the definition I showed you just a few minutes ago of a breach, where a breach is by one party. So therefore, one party in a breach is responsible for something going wrong. In this case, it's beyond the control of both the parties to the agreement, and which renders contractual performance impossible. What does that mean? That means that neither party is able to meet their obligations in terms of the lease agreement. Let's just unpack that for a second. What's happened here is that with the best intentions, tenants wanted to open their stores and continue trading, but they've been forced into a lockdown. They've been forced to stay home. They can't. No matter what they do, they can't. Or they may not still be able to do that going forward under the partial lifting of the lockdown. The landlord had the best intention to make the premises available to the tenant, but he's not allowed to let anybody into the building. So both parties are unable to perform. Usually in a lease agreement, the principal contractual arrangement, besides the payment of rent, is that the landlord will provide premises to the tenant, and the tenant will take up and operate in those premises and either reside in the premises or trade in the premises, and for that pay rent. There's a whole lot of other pages in a lease agreement, but in principle, that's the bottom line. Now here, with force majeure, contractual performance is not possible. Just to give you an example, I'm just going to look at my note here. In 2014, ArcelorMittal, which is a huge steel manufacturing company, had an iron ore mining operation in Liberia and had to close it down because of an outbreak of the Ebola virus. They had to evacuate thousands of their employees, and it caused the mine to completely close down. And they then declared to all their customers a force majeure. What that meant is that they were unable to perform in terms of supply contracts, that they were bound in terms of their relationship to supply to their customers. Now, a force majeure is usually a temporary situation. As hopefully this pandemic is going to be temporary, the circumstances surrounding force majeure will be temporary. Now, we'll touch on it just now, but how do we cope and how do we apply the temporary situation to any relief that might be applicable in terms of a force majeure situation? Now, I mentioned that force majeure there might be a clause in the lease agreement, but there might not be. If there isn't, then there's a common law principle. What is common law? Common law is something that is not contracted, it's not statutorily laid down by the state. In other words, there's no legislation for it. And there's a principle called, I'm going to put up the slide, called supervening impossibility of performance. Let me just share that, 1 second. Screen, sorry, bear with me, please. There you go. Supervening impossibility of performance. What does that mean? It's a common law principle. In other words, it's not contained in any legislation. It's a concept developed over time. The principles of it are that performance, remember this can be performance by either party, must be objectively impossible. What does that mean? It means that no one can tender the performance, both the landlord and the tenant. It would not be applicable if only one party can't perform. That would then potentially be a breach of the contract. It's not applicable if performance has merely become difficult or expensive. What do we mean by that? That means that, take for example the landlord's situation. If he has a bond over his property, the fact that the bank has still continued to finance the property and hasn't called up the loan means that he still has to service that bond, pay interest on the loan. The bank has continued to meet its obligation to provide the finance. Yes, it may be difficult for the landlord, and it might be expensive for him because he might have to extend his bond period and so on. But the point is, I'm trying to show you that it can't just be difficult for one of the parties. It's got to be impossible for the supervening impossibility of performance to apply. The impossibility must be unavoidable by a reasonable person. Now here we come back again to what I was talking about right in the beginning about relationships. Reasonable means the average person in a similar situation. Now, one might turn around and say landlords are unreasonable. Some landlords believe tenants are unreasonable. Reasonability is definable and will be determined, if necessary, by a judge in a court. But a reasonable person in this circumstance would be somebody who's unable to open his business and is forced to stay home. Therefore, it's impossible for him to take up occupation of the premises. And for the landlord, it's also impossible for him. He's also being reasonable. He's making the premises technically available. They're there, you can use them, but you're not allowed to use them. And he's not allowed to allow you to use them because of some government regulation that has been imposed on us, which is a result of this pandemic. So it must be as a result of something like force majeure. Again, it must not be the fault of one particular party. So where does that leave us in a situation in South Africa today? Let me give you a practical example. Let's just assume that a builder, you've got a contract with a builder to build or to do an alteration at your property, whether it's your home or your office or wherever. And there's a deadline. You've set a deadline that this builder has to finish the building by a certain date. Now, because the builder is unable to finish the building, because he's forced to stay home, what happens? Is the contract cancelled? Is the contract postponed? The most reasonable thing to do would be to renegotiate the terms of that contract, because the builder is practically impossible. It's objectively impossible for him to finish that building and to finish the renovation work on time. The point here is that it might be illegal to occupy the premises. So although a landlord might be making the premises available and you might have all your stuff inside those premises, let's assume you're running a shop or a factory, you've got all your equipment and your stuff inside the property, the premises, but it's illegal for you to go there. So this is the result of the government law, and therefore, that's what we're talking about being reasonably impossible to perform. You can't, both parties cannot perform under the terms and conditions of the lease. Now, what is the possible remedies? That's the bottom line. I'm sure you're all waiting for that. What are the possible things that we can do? And it's been very interesting to see some of the articles and the press reports about what's actually happening out there in the real world at this point in time. You probably are aware that a couple of weeks ago, the large clothing companies all turned around to their landlords and said, sorry, we're not paying rent. Now, that was a unilateral decision by the tenants, and they said, we can't go into the property, we can't, the premises, we can't trade, therefore, we are not going to pay any rent. The landlords threw their arms up in the air and said, but hold on a second, you've got a contract. And what's happened over the last couple of weeks, and I've been privy to some particular individual circumstances where there's been an attitude change by both parties. So there are some retailers who have turned around and said, we're not paying any rent. There's some retailers who have turned around and said to the landlords, we'll pay you a portion of the rent, but only a certain percentage. And in particular with these clothing businesses, the large, a lot of them are large listed companies, they offered to pay the landlords 20% of the rental. The landlords said no, and they initially went back with a counter offer of a 35% reduction in rental. And there was a standoff. I saw yesterday an article where a group of the landlords have got together and formed a group, and they have now softened their stance, and they are now offering a 70% reduction in rental to the tenants. The tenants are standing their ground and still saying, sorry, we're not paying you anything, or we're only going to pay 20%. So much so that the landlords are now asking the government to get involved and mediate in the dispute. So one's not sure where that's going to end up, but we'll see how it pans out in time. The point is, the parties are starting to talk to each other. Remember I said in the beginning, this is a relationship. Both parties need each other. Both parties need to succeed. There's no point in South Africa or anywhere in the world during this pandemic for a couple of businesses to do really well and others to fold. For example, if you're in the essential services industry now and you're making maybe sanitizers or face masks, maybe you're doing really well. That's fantastic. But it's not going to help you in the long run if the clothing retailer down the road or the motor car service garage down the road has to close down. We all need to succeed together. It's not going to help anybody if you have a couple of guys who succeed to the detriment of everybody else. So the best thing is to get together and find a solution that is workable for both parties. So coming back to some of the remedies, one of the things that we could look at is for an agreement to be reached for a remission of rental or a discount on the rental. Remission means a cancellation of the rental for a particular period. Now, I know of a particular business that was in a particular center, and on the day of the initial lockdown, I think it was the 27th of March, they approached the landlord and said, please, could we have a remission of rental? And the landlord said, absolutely no way. 3 days later, a credit note arrived, and the landlord had credited those 4 days in March to the rental account. Then, of course, came April. And what's happened there is that that particular landlord has given full credits to the tenants as well for the month of April. What's going to happen in May? I don't know. we're going to have to wait and see what happens. That's one particular centre with one particular tenant and one particular landlord. So a remission of rental, a discount on the rental, or something like that is one of the options that you can look for. You could look for a rental holiday, similar to a cancellation of the rental for a period of time. Remember what we said about the force majeure or the supervening impossibility of performance. It's temporary. So now, how do you phase it in? The same way we're going to phase out the lockdown, how do you phase back, getting back to a normal position? So maybe there's got to be some kind of agreement to phase in rentals. And there's a very interesting concept we'll touch on in a few minutes relating to restaurants. Then maybe the tenant can make partial payments or defer payments, so that, let's just assume you don't pay your rental for April, but you're able to pay it off over the next 12 months. So you would take your April rent, divide by 12, add that to your normal rental and pay it off over time. What that does is that the landlord ultimately is going to get his full rental and the tenant is ultimately going to pay the full rental. Another option is to extend the period of the lease beyond its expiry date. Whether that really helps the landlord is a question that the landlord has to answer, because he would probably have a tenant in those premises beyond the expiry date anyway. So is it helping him to extend the lease? From the tenant's point of view, it would obviously help, because they would then be able to defer their current payment. So those are some of the remedies that might be possible. One of the things we have to consider is, for example, what about a restaurant that's now going to open up tomorrow but can only do deliveries? They're not allowed to have seated patrons anymore, and their turnover, no doubt, is going to be a lot lower than what it was before. Should they be paying now rent from tomorrow? They're trading again, aren't they? There would be an argument both ways. There'd be an argument that they're not able to trade fully, and they're not able to, some of them are not going to open because the cost of starting up their kitchens is just too big. But should they then pay a portion of the rent? And how does one work that out? That's going to be subject to a negotiation between the landlord and the tenant. But it's a very real scenario that's going to start from tomorrow morning. So we need a solution. There's got to be solutions. Everybody needs to survive. In my notes that I made in preparing for this, I wrote the same thing down 3 times. Negotiate, negotiate, negotiate. If both parties, all parties, get around a table and talk to each other, you'll be able to come to some sort of solution. This is tough for everybody. Remember, landlords also have obligations. They've got cleaning services, security services, rates and taxes, bonds to pay, all sorts of things. The same as any business. Businesses, tenants, are overwhelmed. Who do they pay first? Do they pay creditors? Do they pay landlords? Do they pay the bank? Do they pay their staff? So there's just so many issues at hand here that the best way to get through this is to try and negotiate a settlement or a solution between the parties. One very important thing to consider is a future relationship between the parties. You know, it's no good for a landlord to come along and be really tough and hard on a tenant and possibly even kick the tenant out of the property because he hasn't paid rent. Well, then the landlord's going to find another tenant. I'm not sure how easy that's going to be going forward. From the tenant's point of view, if he doesn't pay something towards the landlord, then the point is, what is the landlord going to do? He can't maintain the property. So one has to consider very carefully the future relationship between the parties. And if you've got a relationship, hopefully you can negotiate some kind of deal that will help both parties, albeit difficult, to get through this particular time. We talked about the contract, the lease agreement, and as I said, each lease agreement and each circumstance is going to be a very, very specific set of circumstances. And what I strongly suggest is that anybody who's got any issues and considering taking any legal action, that you go and get some advice. Don't just make decisions on your own. Get some advice, talk to your colleagues, talk to your fellow tenants, talk to your fellow landlords, and make sure that you're doing what's going to work for everybody and be in everybody's interest. Now, I had a couple of other questions that somebody had sent me, and I might run through one or two of them just to cover some technical issues, and then we can maybe go on to questions, because I'm guessing that there's going to be a lot of questions on specific situations. So one of the questions was asked, what if a landlord wants to serve notice of default on a tenant? Now, you've set up your domicilium, which is the address where you're prepared to accept legal notices or notices in terms of your lease, but now you're not at the premises. How is somebody going to serve a notice on you when you're not there? My view is that a court would be very cautious in relying on the fact that a landlord has only served a notice on the domicilium. There needs to be effective service. Effective service means you need to prove that the tenant or the landlord, whichever way it goes, has received the notice. So probably it would be prudent to also serve by email and make sure that your landlord or your tenant has received that notice, if that's the way you're choosing to go. Remember, I've advised I don't think it's the best way to go. Only the lawyers make a bit of money out of that. What if there's a damage to the premises while you are not there? So let's just assume you've got a factory and there's a flood or a fire in the factory while you're not there. You don't even know about it. Now, one of your obligations as a tenant would be to look after the premises and hopefully put out the fire or stop the leak or be aware of it and do something to call in plumbers or whoever might need to be called in to fix the problem, but you're not there. Therefore, you are not meeting your obligations. Again, I think my opinion is that a court would be try and be reasonable and would not force or would not allow, sorry, I beg your pardon, would not allow one party to necessarily be liable because of the fact that they weren't there and there was absolutely nothing they could do about it. One very important thing is that your obligations in terms of the lease do not cease because you don't have occupation of the premises. So for example, if you are responsible to put security on the premises as a tenant, you're still responsible to secure the premises. That's your responsibility. If the landlord is responsible for making sure that the plumbing is in good order, then it's his responsibility, but he's not there. So if there's a flood and he doesn't know about it, you can't really hold either party responsible. It'll be interesting to see how that works out in court, because I'm sure that there's going to be some litigation related to those kind of situations. What about payment of rental? Can some people pay rent in cash, but now the landlord can't come and collect the rent? I think, again, the parties need to agree and cooperate with each other and find some other way, whether by EFT or some other way, to ensure that if there is going to be payment of rental, that it's facilitated as best as possible. Sorry, I'm just having a look at my other question here. A lot of leases contain a clause that talk about destruction of the property through fire or earthquake or whatever might happen. And they say that if the tenant is deprived of beneficial occupation during that time, they will be entitled to a remission of rental. In other words, a discount on the rental, either in full or in part. So again, one needs to look at a situation here where let's just assume that through a fire, the property is damaged during this period and the landlord had, say, 30 days in which to fix the property. Clearly, he's not going to be able to fix it in 30 days. So reasonableness would suggest that that period of time gets extended and the landlord be given more time to complete the repairs. So those are some of the kind of issues, but again, you can see what I'm coming back to always is be reasonable. Negotiate with your other party involved in the lease and see if you can come to some kind of a solution. It's not, I repeat, it's not going to help for people to fight. There's only going to be losers in this. So it's a tough situation that everybody's in. We're not sure exactly how it's going to pan out. We're not sure when business is going to return to normal. We're not sure when everybody's going to be able to meet their obligations. And it's going to play out in such a way that all parties involved in any contract, be it an employment contract, be it a lease, be it some other kind of contract, are going to have to try and work with each other to find a solution that's going to work for everybody. So I think on that note, let me take some questions if there are any questions, and I'll try my best to answer them. There may not be a definitive answer. As I said, there's a lot of grey areas with this, but let's see if there are any questions.
Okay, thank you, Stephen. We're going to just go through the questions from the top. So the first one is, can a landlord charge utilities such as rates, services, waste removal, maintenance, water, CID, levy, etc. during lockdown and beyond while premises are not allowed to be used or occupied? Can a tenant refuse to pay for these?
So again, I come back to what I said right in the beginning. One's got to look at the terms and conditions of the lease. Now, the town councils are certainly not giving a break to anybody and telling them that they don't have to pay rates and taxes, refuse removal and all those sort of things. One would assume that electricity consumption is pretty close to zero if there's no occupation in the property, and hopefully everybody locked their factories and their shops and switched off the power before they left to a degree, geysers and that sort of thing. But it depends very much on the circumstances and on the wording of the lease. Now, a lot of the tenants that I spoke about, these large retail tenants, have offered to pay the landlords the utilities. But again, it's subject to negotiation. They have to be paid. At the end of the day, the landlord is obliged to pay those costs. If you're obliged to pay as a tenant electricity, then you're obliged to pay your electricity. You have to pay it. There's nothing you can do about that, because Eskom are not going to give you a rebate on your electricity charges. Hopefully your consumption's way down and that the bill will be much more affordable than in the normal course.
If a tenant or business goes into liquidation during this time, how does the landlord attach or ensure that they are on the debtors list for rent and utilities due for now and the duration of the lease agreement?
So, okay, that was one of the other questions I had on the list. I didn't get to it. If a business goes into liquidation, and unfortunately the reality is going to be that there's going to be quite a few, then the liquidator, the landlord would have to deal with the liquidator and submit accounts for outstanding rental and stand as a creditor. It's unlikely that landlords have any kind of security unless they have suretyships from the owners of the business, and then they can try and go against the sureties if the business fails, but it would be subject to a liquidator selling off the assets of the business and then distributing any excess to the creditors if there is any excess. But it's a reality that as the business closes, the landlord is potentially losing a tenant, a paying tenant, and is not going to be able to do much about it.
Okay, thank you. If, for example, you've paid your rent for April, what is the clause of saying afterwards when you realize that lockdown has been extended? So if there's a legal term of paying for something under duress, can you in May say, I paid you for April where I didn't use my property? Can I use what I paid you for rent to offset the utilities in May?
So again, it comes down to the negotiation. You're going to have to negotiate with the landlord and see what you can agree. There's no hard and fast rule. There's no, you mentioned payment under duress. I don't believe that anybody paying a rental in terms of a lease agreement is paying under duress. They're paying in terms of the lease agreement. So you'd be quite hard pressed to say that you did it under duress. But I think that it's open to negotiation. By the way, something I don't think I mentioned, I may have, I don't think I mentioned, is that a lease agreement does not have to be in writing. And that's a very interesting thing, especially in residential leases. I know of quite a few people who rent property and they don't have a written lease agreement. So a contract does not have to be in writing. It just has to be able to be proved. And the fact that you can prove it from the fact that people have paid rent and have occupied the property, that's probably sufficient proof that a lease exists. But it doesn't have, a lease agreement doesn't have to be in writing. If it is in writing, you've got to comply with the terms and conditions of the contract.
What if the tenant was not able to move in due to the lockdown?
So there was a question that I had as soon as Lisa put up this webinar. Somebody wrote to me directly and asked that exact question. The problem is that in that particular case, the new tenant had moved out of the relevant province, gone to another province to be with their family during the lockdown. And they were unable to take occupation. Now they're saying, they said to the landlord, well, as soon as things return to normal, we'll come back. And what we'll do is we're happy to extend the lease. Now, again, this comes down to the negotiation and this concept where landlords need to think very carefully. Would you rather have a tenant that is actually able to pay your rent and be a good tenant, but you compromise with them a little bit to give them a break? Or do you want to really be tough on them and say, you know, you owe me the money, now they can't afford it, they might go into liquidation or be sequestrated, and then you're stuck with a tenant that can't pay rent or potentially a property that's unoccupied. So it comes down to the negotiation again. One needs to be reasonable.
In the instance of tenants giving notice because they are forced to close their business, if they have not paid full rent or had received a rental holiday from their landlord, can the landlord withhold returning the deposit to cover any outstanding amounts?
So again, it depends what the terms and conditions of the lease are. If the lease caters for the landlord to hold the deposit back in certain circumstances, then he can do that. But at the end of the day, if the business is closing down, then there's going to be some cost for both parties. And probably the default is that the landlord would be able to keep the deposit and offset that against unpaid rent and unpaid utilities, if there were any.
Okay. What about student accommodation, where students had to vacate due to the lockdown, unable to return due to the lockdown regulations, and also the fact that universities are not reopening for face-to-face lectures anytime soon?
So again, the same principle applies. This is where the impossibility of performance applies. Now, in a residential lease, generally the tenant is staying in the property. So if you are renting an apartment in a suburb somewhere and you are living there, then you have got occupation of that property and you're bound to pay your rental. If you've chosen to move out because the university has closed in this particular case, it becomes a little bit more of a tricky question, because you could have actually stayed there. There's nothing stopping you from staying there unless the particular student accommodation facility completely closed down. Then you were forced to leave. So again, it's a negotiation between the parties.
What about other contractual agreements that are inaccessible, like internet service, and telephones?
So some of the service providers have decided to waive their fees. I know, for example, that Virgin Active have waived their gym membership fees for April, and I think they're going to do it for May as well, until one can go back to gym. I saw a communication today, in fact, that some of the credit card companies have waived the cost of the, those little credit card machines that are in all the stores. So some service providers have given discounts. I see there's a lobby out to get DSTV to reduce their monthly billing costs while this lockdown and pandemic is going on. Whether or not that's going to succeed, I don't know. So I suppose it's really up to each individual service provider as to what they're prepared to do. But I think there are going to be some good deals to be had.
What do you suggest if we have reached out to our landlord with explanation of the impact the lockdown has had on the business and an offer around payment? However, the landlord is still insisting on full rental payment and not open to any negotiations.
Look, again, as I've said, it's not in anybody's interest for the landlords to be really tough about this, and it's not in the interest of the tenant to just turn around and say, I'm not paying anything. They've got to get together. As I said, there's going to be litigation. I don't suggest that anybody wants to be the pioneer in that litigation. I'm sure there's going to be some litigation with some big companies. Let's wait and see how that pans out. And that will probably set the tone. But the point is, you've still got to occupy your property or your premises day to day, and the landlord wants you in there. It's a tough call. Some landlords have been really hard in the beginning, and as I mentioned earlier, a lot of them have now capitulated and they've offered discounts to the various tenants.
So what do you suggest the tenant does? Just makes no payment or makes some payment? Or
one thing you mustn't do is don't not communicate. You need to communicate. You need to be talking to each other. Have a trail. Have a trail of communication, an email trail, so that at least if you eventually get into some kind of an arbitration or a court dispute, you've got a trail and a history of your discussion with the other party, so that you can use that information to build your case and hopefully support your case. But it's a tough call. What do you do? You may not physically be able to pay your rental, and in that case, there's absolutely nothing you can do.
In terms of a residential property, what happens if a tenant has given notice but is not allowed to move? So are they obliged to continue paying rent at the end of the notice period?
Okay, so that's an interesting question, because once again, the terms and conditions of the lease apply. Now, if a tenant in a residential property is given notice, one assumes he's moving to another property. And usually a lease says that the lease will end on a certain date, and if the tenant remains in occupation of the property thereafter, the tenant is still liable for rental on a month-to-month basis, and those conditions, terms and conditions, would still apply. So therefore, anybody staying in occupation would still be obliged to pay. You can't just now squat there and stay there for free. That would be unreasonable. And I'm sure that a court would insist that, or rule that that person would have to pay rental for the period that they're there, albeit that they didn't want to be there. They're now remaining in occupation and have the benefit of that property.
What are the landlord relief funds or options available to them that can be applied for? And if they are receiving this relief, can they still insist on rental from the tenant, thereby capitalizing on both the relief funding and the tenant's rental?
So it's a similar question to what's happening in labour law with the UIF, and whether or not people can ask for a full salary and still then also claim from the UIF. So I'm not aware of any relief schemes specifically for landlords, other than the relief schemes for small and medium enterprises, if it is a small landlord. But certainly I would suggest that landlords go and talk to their financial institutions and try and come to some kind of arrangement with them. I know that they would be prepared to negotiate some kind of deferral of payment. Unfortunately, at this point in time, as far as I understand it, the banks, they will agree to defer the payment, but they're still going to charge you interest. So ultimately, you're going to end up paying a little bit more over the course of your bond, but you may be able to get some cash flow relief, temporary cash flow relief at this point in time.
Is amortization of April, May, and going forward more months a practical solution, given the recovery time of some form of break-even time? It will be impossible on the affordability side to cover those added costs.
So I'm not sure exactly what the question is, but I think when they're saying amortization, meaning let's just say you were paying rent for April and May, and let's just as an example say it's 20,000 Rand a month, you're now saying that that 40,000 would need to be split over the next 12 months of your lease. So that would be close on 3,500 Rand a month roughly. To add on to your normal rental, it's probably going to be pretty impossible for any tenant to afford that. And again, it's going to come down to the negotiation. If you remember, I spoke about those remedies. One of them was a rental holiday. The other one was a deferral of rental. So the deferral of rental doesn't really help the tenant because ultimately he's still got to pay that same amount of money. And unless his business booms, well, I'm not sure where he's going to find the money.
Can a buyer or seller cancel a deal of selling a property if the buyer and seller can't move out because of the lockdown?
I'm not, it depends again on the terms and conditions of the sale, agreement of sale. I would think that there would be a very strong argument that there should be flexibility and leniency given in that the periods for meeting the suspensive conditions related to a property purchase or sale would be extended over this period of time so that the parties can meet their obligations. If a party now wants to renege on the deal completely because they believe they can't afford it going forward, well, that's a different thing, and I suggest that person gets legal advice. I'm involved in a couple of purchase and sale agreement disputes at the moment, and they are pretty technical.
Can a company give notice to terminate the lease ahead of the expiry period of the lease because of the current situation and economic effect of the pandemic?
Well, then it potentially depends on, again, on the terms and conditions of the lease, but potentially that could be a breach of contract. And, you know, one needs to look at the terms and conditions and see who's entitled to do what and under what conditions can you terminate a lease agreement. In a residential lease, generally the tenant is able to give 20 business days notice, regardless of the period of the lease, but subject to them paying some kind of a reasonable cancellation fee to the landlord. So I certainly wouldn't think that landlords would want to be cancelling leases if they've got a paying tenant. I think the landscape going forward is going to change, and I think landlords are going to value their tenants maybe a little bit more than they may have in the past. I'm not saying they didn't in the past, but I think that that relationship is going to be critical going forward.
Okay. Our retail business at the waterfront is 100% dependent on international tourists. In all likelihood, it will take a long time before international tourists return to Cape Town. The waterfront used to be visited by 4 million international tourists annually, and this will no longer be the case. As such, what we were sold, a venue with high foot count of international tourists, no longer holds true. Is this grounds to cancel a lease, which at the moment runs for another 12 months?
Again, cancellation means that you are changing the terms and conditions of the lease. You'd have to look at the lease agreement and see. Now, one of the examples I forgot to give you in the initial discussion was, for example, there's some chains of businesses that have been operating now throughout this period, and they've gone to the tenant, to the landlord, and said, we're not going to pay the full rent. The landlord's saying, but you're trading. You're an essential service and you've been trading. Now, tenant's point of view, I can almost understand it because the tenant might be selling certain things that are essential services and certain others that are not, which they're now not able to sell. So that's the one argument, that their turnovers are down because they're not able to sell their full range of goods. And the second argument might be that there's less foot traffic coming through the centre. Now, that, of course, a downturn in turnover, which is exactly your question for international travel. It's going to be a matter of survival, and both parties are going to need to cooperate with each other and possibly negotiate a reduced rental going forward. I think landlords are going to be quite happy to have a tenant stay on in the premises, even at reduced rentals, but it's got to be negotiated.
If a tenant is in Durban and she's not yet allowed to travel provincially, but the lockdown is lifted for people to move in, but the property is in Cape Town, what would happen regarding the rental payment? What do I do if a tenant will only pay 2,000 Rand if the rent is 13,000? Can I legally give them notice?
So as far as I understand, the lockdown restriction that's being lifted is that people will be allowed to move once if they are returning to their place of work. So you'll be allowed to move interprovincially if you're returning to your place of work, but you can move once. So, for example, if you went to Durban to be with your family during lockdown and your job is in Johannesburg and you're now moving back to Johannesburg because you're able to go back to work, then you're allowed to move interprovincially. In terms of the tenant who's been unable to take occupation, and we touched on it earlier, the landlord, again, needs to consider very carefully whether or not in the long term this is going to be a good tenant who they want, and they might have to consider some kind of a discount in the rental for now and hopefully have a tenant going forward into the future. It's not an easy decision, but again, cancellation is difficult and it depends on the terms and conditions of the lease agreement.
And the last two questions. If an arrangement is made with the tenant to pay their rent in installments, would it be appropriate to get the said tenant to sign a document confirming this arrangement?
Well, if you can get an acknowledgement of debt from anybody, that certainly helps you if one day you end up in court having to fight for it, because then you can prove your case much easier. So certainly, whatever arrangements you come to, try and get it agreed to in writing, because you never know what the dispute might be further down the line.
Okay, and the last question is similar thread to what we've had before. If a landlord's not open to negotiation or sitting around a table to talk in terms of a rent reduction, but he still expects full rental, although over an amortized period, can he legally apply interest?
In terms of the lease, he probably could apply interest. I think that again, it comes back, I know it's the same answer that I'm giving all the time, and that is negotiate, negotiate, negotiate. Because a landlord who's really trying to be difficult might have that tenant for the remainder of their lease, and let's say it's a residential lease, for example. It doesn't matter, residential or commercial. And at the end of that lease, that tenant might turn around and say, you know what, this guy never supported me when I needed him, so I'm going to move out. And I don't want to be part of that relationship anymore. Now that landlord has to find a new tenant. Whether he's going to be able to or not remains to be seen. So it's a negotiation.
Okay, thank you. I think that brings us to the end of our session this morning. Thank you, Steven, so much for your time and for your insights, and it's quite a complex area at the moment. So thank you for being open to answering in as much detail as possible. For everybody else, thank you for attending this morning. If you are interested in attending any of our other webinars, please just pop if you're not already on our database, please pop your email address in the chat box, and to make sure that you will receive all our other invitations. And keep checking our ORT Jet Cape Town Facebook page as well for our other online events that we're organizing in the next few weeks. Thank you.
Thank you.